Are you letting people in already or until
Yep.
12?
Yep.
Yes. All right, welcome everybody. We'll be starting in a few minutes.
All right. I have just noon. We'll give people another minute or two, but not long, and then we'll get started. We've got a lot to cover today.
Yeah, for sure. Okay.
For those of you that are wondering, because we usually get this question, the session is being recorded, and you will be able to see the recording in a few days on the California Department of Financial Protection Innovations YouTube channel, which you can find a link to on their website. And just because we have so much to cover, Celina, you ready to go?
Yeah, we can get going.
Let's do this.
Yeah, all right. Let's see. All right. Welcome everybody. Good afternoon. My name is Celina Damian, and I am the Student Loan Servicing Ombudsperson here at the DFPI, or the Department of Financial Protection Innovation. I'm joined today by Betsy Mayotte, who is the founder, president of TISLA, the Institute of Student Loan Advisors. So we have done many of these webinars today. Thank you for joining us again. As Betsy mentioned, this webinar will be recorded and will be posted on our DFPI YouTube channel in a few days. You can, throughout the entire webinar, your video microphone will be muted, disabled. You can enter questions in the Q&A function, and then just hold off any questions, personal questions, things like that, because this is a public forum. So thank you again for joining us. So if you're joining us, it's probably because you have student loans, you're a student loan borrower, and you have some questions. We understand that this is a confusing, turbulent time. There's a lot going on, and we are here to help you with those questions, help you navigate your loans. So we're here to provide you up-to-date information, guidance from the Department of Education, and then just help you with whatever questions you may have. So as I said, it will be recorded. Let's get going. Let's get going. So about the DFPI, we are California's Consumer Protection Agency. We regulate companies of financial products, and this includes your student loan servicers. So in California, in addition to all the other financial servicers, we do license the servicers that are contracted by Department of Education. So that's where we come in. We accept and we evaluate consumer complaints, and we take enforcement and legal action when these companies are not in compliance. Excuse me. And we conduct education and outreach, such as this one, to protect consumers from fraud and abuse. Next, please. TISLA is a nonprofit that offers free, expert, unbiased student loan advice. They have been around. Betsy has been helping thousands of borrowers nationwide, and she is a student loan expert, and I love working with her. So Thanks for being here, Betsy. And there's her website. We will have our emails and information at the end of the webinar as well. Next, please. Some numbers about our debt in California. We have 4 million borrowers that owe approximately $141 billion of debt, and most of that is federal debt. The average debt load of a California borrower is $37,000, and the majority of debt is held by borrowers between the ages of 35 to 49. We have a default rate of 7%. And between 1995 and 2017, the balance of the federal student loan debt has increased more than sevenfold. We're currently at $1.78 trillion of student loan debt. Next slide, please. It is the second highest consumer debt category. However, there are some good news and some bright light in all this. As of mid-July 2024, Biden's administration has approved debt cancellation for approximately 4.76 million borrowers, totaling $168.5 billion in forgiveness. And I just saw just last night, the Federal Reserve Bank of New York reported that in the second quarter of 2024, student loan debt decreased by $10 billion. That has to do with the forgiveness program. So this 68 billion is 69 billion in PSLF, 51 through the adjustments made through IDR, 28.7 billion through borrower defense discharge, some through TPD, the total permanent disability, and then 5.5 through the SAFE plan. So there is some good news in all of this, and we just wanted to share that with you as well. Next, please. The California Student Borrower Bill of Rights, it's a state protection for student loan borrowers, Assembly Bill 376. It applies to servicers. So those are the companies that are servicing your loans, Mohila, Nelnet, Advantage, prohibits servicers from engaging in abusive, unfair or deceptive practices, and it requires that they work in your best interest. They have to provide you accurate information and applications for IDR plans and other forms for federal benefits and protections, and it establishes special protections for military borrowers, those working in public service, older borrowers, and those with disabilities. So that has to do with the federal forgiveness plans. It protects borrowers from any negative consequences stemming from a sale, assignment, transfer, system conversion. This is really important right now. We've had tons of transfers. Your loans may have been transferred from one servicer to another. It's important that you don't incur any negative consequences. Your accounts are the same, your balances are the same, that you don't lose your auto pay, things like that. And then a borrower has the right to take legal action against their servicer if they fail to comply with these laws. In California, we have what is called a private right of action. And this protection applies to borrowers with both federal and private loans. Next, please. And then just the agenda, we're going to go over the federal repayment plans. We're going to talk about the SAVE litigation, some PSLF and IDR adjustment updates, the new debt relief announcement. We're going to talk about that, and then just how to stay informed and then provide you with resources. So Betsy, take it away.
Thanks, Celina. So I'm really glad that Celina highlighted the student debt that has been forgiven so far under the current administration. And one of the reasons I'm really glad she highlighted it is, as she mentioned, we're in a really chaotic time right now in the student loan industry. I've been working in the student loan industry in a compliance and advocacy role since the dinosaurs roamed, and I have never seen anything like what's going on lately happen before. So we're really in uncharted territory. And I know a lot of borrowers were getting, at least the ones that we work with, are feeling a little defeatist because of the various court actions that have blocked certain attempts at broad loan forgiveness and currently the SAVE plan. But it really stands to remind people, it's important to remind people that despite these roadblocks, this administration has forgiven debt for quite a significant number of borrowers, and a lot of the policy changes that have been made that are not being challenged in court will continue to help borrowers going forward. So I guess what I'm trying to say is don't let it get you down. There's still a lot of good news here. Um, just as an aside, I'm about to turn my camera off because my face will contribute nothing to the rest of this presentation. Um, and then we can get started into the meat of the issues. So I want to start out by sort of doing a primer. I want to give people an overview of the various repayment plans that are available, or were available or might be available again to federal student loan borrowers. We don't have time to go into the gory details of these individual plans. That is a presentation all on its own. But you can find out more information about these plans at the Department of Ed's website, which is studentaid.gov, and maybe one of my team members will throw that up in the chat panel for people. We also have all the websites that I'm going to mention listed at the end of this presentation. You can also find out detailed information about these payment plans on the TISLA website, shameless plug, which again is freestudentloanadvice.org. But essentially, we sort of have an abundance of riches when it comes to the various repayment plans available to federal student loan borrowers. The downside to that is it can make things confusing. We almost have too many, which is something that the Department of Ed was trying to work on to sort of simplify the options. But if you take a step back and look at them at a broad level, there's essentially two buckets of repayment plans. There's the bucket of plans where your payment amount is going to be based exclusively on your balance and interest rate. And then there's the bucket of plans where your payment amount is going to be based almost exclusively on your adjusted gross income and your family size. So the first bucket of plans, which are the plans you see on the left-hand side of your screen, let me just say none of those are at risk right now. They are all currently available. If any of them are a good fit for you, you can apply for them today, and they should be processed fairly quickly. None of these plans on the left-hand side are being blocked by any of the court actions. So that includes the 10-year standard plan. Now, the 10-year standard plan is the plan that you're going to get put on if you don't actively choose a plan when you first go into repayment when you get out of school. And that tends to be the least expensive plan. You're making the same payment amount every month for 120 payments, which is 10 years. This is the only plan in this bucket of plans that's also an eligible payment under both public service loan forgiveness and the income-driven plan forgiveness components. The other plans that are based on balance exclusively are the extended repayment plan, which essentially it's sort of self-descriptive. It extends the term of your loan, therefore it lowers your payment. You do have to owe at least 30 grand to be eligible for that. Graduated repayment, which I call the granddaddy of the lower payment options because it's the oldest one. That one is interest only for your first 2 or 4 years, and then the payment gradually goes up year by year, but you're still paying the loan off within 10 years. And then if you mush those two together, you get graduated extended, which is interest only for the first few years, but they are also extending the term to 25 years. So that'll give you overall a lower payment. Now, on any of these plans, you can pay extra. And the name of the game, we get caught up in the word forgiveness, and I get it. I am a sucker for a buy one, get one free at the grocery store, just like everybody else, without actually doing the math. But the name of the game is paying the least amount out of your own pocket over time. And for some people, that means pursuing a loan forgiveness program. And for other people, it's going to mean paying their loans off as aggressively as possible to reduce total interest costs. What you don't want to do is both of those things. I see people that are actively pursuing public service loan forgiveness, but they're making extra payments. And that doesn't make any sense because, again, your goal is to pay the least amount out of your own pocket over time. So in general, you're either paying your loans off as fast as you can to reduce total interest, or you're pursuing a loan forgiveness program. Speaking of loan forgiveness, let's look at the other bucket of payment plans, and those are the plans that are based on your income. Now, the umbrella term that we use for these plans is income-driven repayment, or IDR. So if you hear Celina and I use the term IDR, or income-driven, we're talking about all of these plans that are based on your income. But if we say IBR, or income-based repayment, or SAVE, or ICR, we are talking about that individual plan itself. Now, all these IDR plans are exactly the same except where they're different. They're all based on your adjusted gross income, and if you're married and you file your taxes as married, it will include your spouse's income. It doesn't make them legally obligated for the loan, but they'll include the income in the calculation. Um, and then they subtract a percentage of the poverty level that's based on your family size and state. So, for example, for this year, the poverty level for a family size of 4 in all the states other than Alaska and Hawaii is a little over 31,000. So, depending on the plan, they're either subtracting the 31,000 if you're a family size of 4, or for some of the plans they subtract 150% of the poverty level, and some of the plans they subtract 225% of the poverty level. The SAVE plan is the most generous in that regard, which is why we're all sort of biting our nails to see if that plan is going to survive the court actions. The other thing that these plans all have in common, well, there's a couple other things. First of all, you're required to recertify your income on an annual basis. People might forget that because we haven't had to do that since COVID started. But that is probably going to restart shortly. It was supposed to restart in November, but my gut tells me that because of all these court shenanigans, that they may extend the recertification deadlines again. But eventually, when we get back to real life, you will be required to recertify your income annually. And then these plans also have a forgiveness component baked into them. So that has nothing to do with your employment. But if you're on these plans for either 20 or 25 years, depending on what kind of loan you have and depending on the plan, then the balance is going to be forgiven. Now, the forgiveness, excuse me, the forgiveness for these income driven plans is currently paused because of the court shenanigans, and I'm going to talk more about that in a few minutes. I but I will tell you that absolute worst case scenario, IBR is written into federal law, and only Congress can change federal law. So, worst case scenario, there will still be a forgiveness income driven plan available under IBR, regardless of what happens with the courts. Um, I mean, of course, I don't have a crystal ball, but I think that we'll have other IDR forgiveness available after the courts as well. It's just a matter of whether SAVE and or some of the other ones survive it. Now, the best way to determine which payment plan is best for you is to use what's called the loan simulator tool, which you can find at studentaid.gov. Now, that tool is great because you just have to plug your information in once and it'll tell you what your monthly payment will be under each of the plans. And almost more importantly, it's going to tell you how much that's going to cost you out of pocket over time. Now, things are a little, because everything's a little squirrely right now, I would use that calculator as more of an educated guess right now because things could change because of the court actions, but it's a good baseline to use, and especially for the non-income based plans, you can definitely count on it. I mentioned how the income driven plans work. They take your adjusted gross income and then they subtract a percentage of the poverty level based on your family size. The result of that is what we call discretionary income. I wanted to make sure to spell out what discretionary income means because that's a term that we see every day, but it means something very different to most of us than it does when it comes to the income driven plans. To most of us, when we hear discretionary income, we hear what's left over after we've paid all our bills, and maybe put money into savings and in retirement and all that. Discretionary income under the income driven plans is very specifically defined as your adjusted gross income as you find on your most recent tax return minus the poverty level based on your family size and state. So I want, if you have other bills, that's not included in that calculation. Just to give you an example of what that might look like, if you have a borrower who is a family size of 4 living in Maryland and they have an AGI of 62,000 and they were applying for either new IBR or pay as you earn or the old repay plan, all of those used 150% of the poverty level, that borrower's payment under new IBR and pay as you earn and the old repay would be $189. Under old IBR, their payment would be $283. Now, to show you what an impact that the SAVE plan has had for many borrowers, if you take that same family with that same income, their payment dropped last year to $25.41. So it would have gone from $189 to $25 a month. And then this past July, when the payments were supposed to reduce under Save again, it would have gone to almost $13. So again, you can see what a significant impact that the Save plan would have on a lot of borrowers' budgets. Hopefully it survives, or even if a piece of it survives, you can see it will still help a lot of borrowers with their monthly budgets. So let's talk about that litigation. Actually, before we talk about that litigation, Addison, I want to check in with you to see if there's anything I've covered so far where we might have some questions you think I should dig into.
No, not at this time.
Okay, thank you. All right, so as I mentioned, the SAVE plan was written into regulations about a little over a year ago. And the minute the new regulations came out, which was last July, the Department of Education chose to implement it as soon as possible. Usually new regulations don't get implemented for about 6 months after they're published, but this administration knew how much that the SAVE plan would help people, and they wanted to implement it right away. So basically, anybody who was on the old repay plan was automatically switched over to SAVE. Most people were switched over by August of 2023. And what the difference between repay and SAVE is repay used 150% of the poverty level. SAVE uses 225%. So you're starting off with a lower amount that they're calculating off of. SAVE also has a really generous interest subsidy where any amount of interest that accrues per month that is more than what your calculated SAVE payment is, the government's going to forgive that interest. So one of the critiques of the other income-driven plans is that, sure, there was a forgiveness component at the end, but it was a little soul-sucking to make a payment every month, and if your payment was lower than how much interest you were accruing every month, people are making payments only to watch their balance increase every single month. And with SAVE, that doesn't happen, because if your payment is less than your monthly interest, the government forgives that for as long as you're on the SAVE plan and as long as your payment's less than your interest. The other difference between repay and SAVE is that for repay, you were required to include your spouse's income in the calculation regardless of your tax filing status. And with SAVE, they made it the same as all the other plans. If you file your taxes jointly, they utilize spousal income in the calculation. If you file your taxes separately, they don't. And since SAVE was implemented, we've had almost 8 million borrowers enroll in the plan. And as a result of SAVE, and as a result of the one-time IDR income-driven plan adjustment waiver, which we're going to talk about in a little while, as of this past May, so as of the beginning of the summer, almost 55,000 borrowers received forgiveness directly related to the SAVE plan. Now, the SAVE plan, the forgiveness is if you have only undergraduate debt, so you've never taken even $1 out in graduate loans, the forgiveness is after 20 years under the SAVE plan. If you have even $1 in debt from grad school, federal debt from grad school, then your forgiveness turns into 25 years under the SAVE plan. But SAVE also had an early forgiveness component where if you only ever borrowed 12 grand or less and you were on the SAVE plan, they didn't drag it out to the 20 or 25 years. You got forgiveness in 10 years. And that's really important because that's one of the things that the plaintiffs in the lawsuits against the SAVE plan, that was one of the two things that they really had their knickers in a twist about and that they're really pushing back on. So let's look at the timeline of this. So as I mentioned, in end of June, beginning of July, the Department of Ed released and published the final rules for the SAVE plan and asked the servicers to implement everything right away other than the 5% calculation, which wasn't going to go into effect until this July of 2024, and the 10-year forgiveness for small balances. They held off on that until this past summer as well. In April of 2024, two separate groups of Republican-led states, so you're looking at the Attorney General's offices in these Republican states, filed lawsuits to prevent certain aspects of the SAVE plan from being implemented. Specifically, what they had heartburn over was the 5% payment cap calculation that was due to go into effect this summer, and the early forgiveness for low balance borrowers. Those cases were filed in the 8th Circuit, which is Missouri, and the 10th Circuit, which I believe is Texas, but don't quote me on that. And then in a couple months later, each court, Missouri and Kansas, each court issued an injunction blocking at least part of the SAVE plan from being implemented. In Kansas, they blocked the part of lowering the payments to the 5%, and in Missouri, they blocked the early forgiveness for low balance borrowers. The Department of Ed managed to get the first one of those lifted in about a week. And then just about a month ago or a month and a half ago, the Missouri court ended up blocking the entire SAVE plan. And that's why we're at where we're at right now. So there was a lot of pushing and shoving. And in the end, the court just said, listen, nobody can do anything with the SAVE plan until we figure this case out. And, that's something important to realize. With all this back and forth with these injunctions, the case hasn't even been heard yet. So that's what we're waiting for. So SAVE is on hold now until this goes through the courts. And what we fully expect to happen is, regardless of what the court decision is about the SAVE plan, we expect whoever loses to appeal, and that it might eventually end up at the Supreme Court. And what that means to you is that if you're a borrower who is currently on the SAVE plan, you've likely already seen that your loan has been put into a zero interest forbearance. Now, when I say zero interest forbearance, I want to preempt a question, a really common question. The servicers handle those zero interest forbearances differently, and we saw this during COVID. Those of you that were in repayment during COVID, you might remember you got put in forbearance, and that was also supposed to be a zero interest forbearance, and it eventually was, but people thought that there was a mistake going on because they still saw interest accruing, especially in the beginning. Some servicers back that interest off later, but it's still effective the date of the date of the whole forbearance. Some servicers do it on a monthly basis. Some servicers do it all at the end. But if you're on this SAVE zero interest forbearance, any interest that would have accrued during the period of that forbearance will go away, and you won't be held responsible for it. So that's the good news. The bad news is that if you are in the SAVE forbearance and you're pursuing forgiveness under either public service loan forgiveness or any of the income-driven plans, these months don't count towards forgiveness. Now, there may be some remedies for that. Well, there are some remedies for that, especially for PSLF borrowers, specifically something called buyback, PSLF buyback. And Celina is going to talk about buyback in a few minutes. Now, the other people that are victims of this nonsense, excuse me, are borrowers that had a pending income-driven plan application, whether it was for SAVE or whether it was for old IBR or new IBR or pay-as-you-earn. The injunction means that, at least for now, the servicers can't process any applications for income-driven plans. So those people are in limbo. They're not in the SAVE forbearance, so they're still accruing interest, and they're showing due for payment, and a payment that might very well be unaffordable. If it was affordable, they probably wouldn't have applied for an income-driven plan. So what the Department of Ed has recently announced for those borrowers, and I will admit we are waiting for some additional guidance, is that borrowers who apply for an income-driven plan now or have a pending IDR application, they will end up getting put in what we call a processing forbearance for 60 days. Now, the processing forbearance, as opposed to the SAVE forbearance, interest does still accrue, bad news, but those months also do count towards PSLF forgiveness as well as income-driven plan forgiveness. So that's the good news. Now, if that 60-day processing forbearance comes and goes and they're still unable to put you under an income-driven plan, then you'll be put in what's called general forbearance. Now, general forbearance interest accrues. It doesn't count towards forgiveness, but especially for borrowers that are utilizing buyback, um, pursuing PSLF, you'd be able to utilize buyback to get those months to count down the line. You know, I think we'll receive some additional guidance from the Department of Ed in the coming months. Sort of a big thing to watch for is there's going to be some court arguments next week on some of this. And I think some additional guidance that we might be waiting for may come out as a result of whatever the outcome is of those court hearings next week. But you know, based on the calendar for the Supreme Court, just to sort of set expectations, for those borrowers that are currently on the SAVE plan in particular, you could be in this SAVE forbearance as long as next summer. Now, for those of you who that's freaking you out a little bit, your options are you can apply for another income-driven plan. Remember, they're not processing any of those right now, but I expect those might loosen up before the SAVE plan is settled, so at least you'd be in the queue. But you know, you need to look at the pros and cons of doing that, especially borrowers that are pursuing PSLF. My advice right this second is to stay put in your SAVE forbearance and plan on utilizing buyback down the road.
Thank
The
you,
other
Betsy.
reason,
I'm sorry.
Sorry, let me just get this out of my
Yes.
mouth and then I'll.
Go ahead.
So the other reason that especially borrowers pursuing PSLF might want to just stay put for now is that chances are, if you switch to a different IDR plan, once they do open those back up, your monthly payment is probably going to be higher. And depending on how you switch and what you switch to and from, any outstanding interest might capitalize or be added to your principal balance. So, you know, staying on the SAVE forbearance might not be the right decision for everybody. You know, every situation is unique and different. But from a high level, at least the way things are right now, that tends to be my recommendation. Somebody had a question, comment, or gripe. Was it you, Celina?
No, I was just gonna see if there were any questions that we wanted before we moved into PS. If there were any SAVE.
Okay. Somebody had a question. Was it you, Addison? No?
No, not me, but there did seem to be some confusion over a few questions about the difference between PSLF and income-driven repayment plans, whether you can be on both at the same time.
You almost have to be. So, public service loan forgiveness is a forgiveness program. In order to qualify to get your balance forgiven after 10 years, you have to work for 10 years for at least 30 hours a week for a qualifying employer. And that's generally a government employer and many, but not all, nonprofits. You also have to be under a qualifying plan. The only plans that qualify for PSLF under the regular traditional rules are the 10-year standard plan or any of the income-driven plans. So that's PSLF. But the income-driven plans have their own forgiveness component baked in that's separate and distinct from PSLF. So if you're not working for a PSLF eligible employer, or if you don't end up working for one for the full 120 months, you can stay on an income-driven plan for either 20 or 25 years and still get your balance forgiven. And there's no actual employment requirement attached to the income-driven plans. Was there anything else, Addison, you thought I should try to explain?
No, I think that's it.
Okay. All right, take it away, Celina.
Okay, so I think you pretty much covered this one, so
Sorry.
that's okay. So what the litigation means for PSLF, so you would, if you're enrolled in SAVE, you have been placed on this forbearance that where you are not receiving qualifying credit towards PSLF. Okay, so As Betsy mentioned, you can enroll in a different IDR plan. However, just there are going to be delays, and make sure you understand your options. Next, please. Let me talk about the buyback. So PSLF buyback is a new program that was part of the new PSLF regulations. Through this program, a borrower is able to buy back previously ineligible months of forbearance and deferment for PSLF purposes. So to utilize this program, you have to have a direct loan, of course, with a balance. You have to have 120 months of qualifying employment. So you have to have already qualified that employment, and then buying back some of these months will complete your 120 payments. So as you can see in this graph here, it depicts it perfectly. So let's say, for example, for some months you were placed on forbearance, deferment, or you just had a few months where like in this case, where you weren't able to receive an eligible PSLF month. So the Department of Education is allowing borrowers, once they reach the 120 of qualifying employment, to go back and purchase those months or pay for those months. Now, you're going to be applying through studentaid.gov. There's going to be a buyback agreement with this program. You're going to be, if you were on an IDR plan, you're going to be paying what you were paying, let's say the month before or after, the lowest month. If you were on a $0 payment, you would receive automatic forgiveness. However, the only thing here is that right now they are strongly encouraging borrowers to just hold off on doing buyback, because they still haven't finished all the updates for PSLF. They still haven't finished all the IDR adjustment review. So they're currently in review of those months. So you may have months in forbearance and deferment showing right now, but that doesn't mean they may not become PSLF eligible once they do the update. So right now, the counts that you're seeing, and we can move on to the next one. Right now, the counts that you're seeing are not going to be accurate. So this buyback program is going to be through Department of Education. You don't call your servicer. They're not going to be able to assist you with that. And then, which leads me to this, just a reminder for those on PSLF. As you may have seen already in your portals, PSLF has transitioned to studentaid.gov now. So you're no longer dealing with MOHELA as far as the certifications, the counts. So they're managing the PSLF program now. So you're going to be able to process the forms on there, see your update counts, and then you'll have to request the forgiveness once you reach the 120. So right now, the information is not updated. It's not updated for your counts. They were hoping to have everything moved over by November, but as we're hearing, there's going to be delays. So when there's a delay in one area, it's going to delay other areas, just because it's save the litigation is a priority right now. You may be able to see some information on studentaid.gov, but I would recommend that you go in there and that you start clicking on those links, start really exploring and see what information is available there. The same information, your same counts should be updated there. You may just not see all these certifications. Moving forward, when you use the studentaid.gov tool or the help tool, you'll be able to see the process of the certifications from your employer. So remember, you can still continue certifying employment. You just may not see those PSLF qualifying months updated. So you can still do that process, and you may not be able to pull up prior to July 1st information. So we're hoping to get all that up and running, but the hope is that once all this is ironed out, strained out, even in the courts, that studentaid.gov will be much more efficient, and borrowers will be able to see the information much more easily there in one site. Next, please. And then what does all this mean for the one-time IDR adjustment? I know for those of you that consolidated recently, you consolidated, maybe we're switching over to an IDR plan at the same time. You may be stuck in a place where you're now placed on forbearance. We didn't anticipate this happening, right? The IDR adjustment was another program that was rolled out to provide relief to borrowers, those with 20, 25-year loans, right? We're going to get forgiveness, and some did, right? But because of the timing of everything, that has been put on hold, it's still taking place. They are still reviewing accounts to update the information from your previous servicers, from those failed loans, to update everything, but the forgiveness is paused, right? Because of the litigation. So I know some of you may be a little bit concerned about that. And I know that, I talked to many borrowers who we discussed kind of what was best for them, and they did decide to consolidate, and now unfortunately they're here. But we want to keep everyone updated and want to just be clear about what's going on. So the forgiveness is paused. That doesn't mean that your information is that they've backed out on giving you credit, that they're not going to transfer all your information. That is still taking place. So, and the information that you're seeing with your servicer or on studentaid.gov may not be accurate as well. As I said, it's not updated. So I wouldn't count on that right now. Just make sure you keep your records, that you have an idea of where you're at. And then you can always pull up your NSLDS, download your file on studentaid.gov that has all your history going back to initial loan disbursements. Next, please. One thing we do want to remind borrowers of is the end of the on-ramp period. When we had the COVID payment pause for 3 years, started March 2020, ended September 30th of last year, the Department of Ed created the on-ramp period, which was 1 year where borrowers who did not make payments were not reported to the credit bureaus. They weren't all default actions paused, or consequences of the collections, all those were paused. And then this was for any late, missed, or partial payments. So it really gave borrowers a chance to get themselves back on track without incurring those negative consequences. Interest was still accruing, and they weren't receiving credit for the forgiveness programs, but it was a good chance for borrowers to get back on track. So starting October 1st, it is the end of the on-ramp period. So borrowers who are not making payments, or who do not make payments, will start being reported to the credit bureaus. So if you're 90 days more past due, you will start seeing that on your credit report, and then collections for borrowers with default loans will resume. So it's really important that if you are still not sure, that you just explore your payment options and get yourself back on track. That way you don't see any of these, credit affected, and you don't want to go down that delinquency default road, especially since we've had a whole year to get back on track. Next, please. And then it's also the end of the Fresh Start program, or enrollment, the open enrollment for the Fresh Start program. This is a one-time program that was created for borrowers that were in defaults. These was borrowers with federal student loans, with defaulted direct and FFEL loans, and then Perkins loans, all held by Ed. So basically through this program, you enroll and you get yourself back on in repayment in good standing, and you're able to get on an IDR plan and then get back on track. So typically when a borrower defaults, they have other options where they can either consolidate, or they have other options. But this is a one-time opportunity where it's going to be immediate, and borrowers just have just an additional opportunity. So it's a really good chance for those. Have until September 30th to enroll. It's really easy to enroll. You can call this number, or you can log on. Some of you may have received information on these. So just make sure that you know the status of your loans, because we've been in this whole pause and repayment, you may think, oh, I haven't heard anything about these loans anymore. Maybe they went away. Maybe it's not because they went away. It's just because of the on-ramp. So if you really want to get back on track, you can call them, you can log on to the studentaid.gov, or reach out to any of us to find out. But you still have a few more weeks for this program, and then you'll be able to get back on an IDR plan that works for you. Next, please. And then I'll hand it over to Betsy for this.
Thank you, Celina. All right, so let's talk about the other forgiveness or relief that is currently in limbo, which is it's often called the Biden-Harris debt relief. So if you remember, President Biden, during his campaign and since his campaign, has been talking about forgiving student loan debt, for a very long time. To be clear, because there's some confusion about this out there, he never said that he was going to forgive all student loans, but he did say that he wanted to provide he recognized that it was important to provide some student loan debt relief. So his first attempt was in August of 2022. And if you remember, we were still under COVID at that point, which is important because the authority, we have to remember, so here in the United States, we have a president, not a king. And the president of the United States doesn't change laws. They don't make laws. Congress does that. There's a reason that our founding fathers created the three branches of the government. And Congress is the one that makes the laws, and the president has to follow those laws. But during COVID, we were under the CARES Act, and that gave the president some temporary authority to do things that were in other times when we weren't under the CARES Act might have been seen as contrary to federal law. So under the CARES Act, he announced a plan, or I should say the administration announced a plan that would have canceled up to $10,000 in federal student loan debt for most borrowers. And for those borrowers that were low income when they were in college and therefore had received the Pell Grant, it would have forgiven up to $20,000 for those borrowers. And this whole thing would have only applied to borrowers whose income were either less than 125 grand, or for married borrowers less than 250 grand. So pretty much the same cast of characters that filed lawsuits against the SAVE plan a few months ago. They filed a lawsuit saying that the president was going beyond his authority and even beyond the CARES Act authority. And it went through its paces, and in the end, the Supreme Court ended up striking down that plan in June of 2023. It was actually right around the same day that it was struck down by SCOTUS is when they announced the SAVE plan, and they also announced that they weren't done yet, that he was going to try to continue to fulfill his campaign promise to try to do broad debt relief for borrowers, especially the most vulnerable borrowers. So on that same day, they announced what's called negotiated rulemaking. Now, negotiated rulemaking is where the Department of Education and other agencies use negotiated rulemaking as well. They create new regulations or change existing regulations. And one of the rules of NEGREG is that they can't do anything contrary to federal law. So this sort of second bite at the debt relief apple is under, the White House and the Department of Education is stating that the Secretary of Education does have some authority under federal law to forgive some student loan debt in certain cases. And so they went through this negotiated rulemaking process to sort of make it legal and follow the legal process for that. They came out with draft rules a few months ago. And then on July 31st, they said, in anticipation of the final version of these rules coming out, we're giving borrowers an opportunity to opt out of this forgiveness if they want to. And just as an aside, before anybody asks, why would I want to opt out of forgiveness? There are at least 4 states that would tax this on the state levels, tax the forgiveness. And especially for borrowers pursuing PSLF or borrowers who are receiving some sort of benefits that are based on their income, it actually might make sense for them to opt out of this debt relief. So they gave borrowers until the end of August to opt out, and then we anticipated the final rules being published. And my guess is that the Department of Ed would have started doing forgiveness to whoever was eligible for it right away. Well, again, same cast of characters. They filed a lawsuit, which was interesting because we don't have the final rules yet, so they kind of don't know. I mean, we have the draft rules, and we think the final rules will be at least similar to what the draft rules were, but essentially they're filing a case against something they don't know what it is yet. We don't know what it is, but we don't like it. So the courts issued an injunction saying that the Department of Ed couldn't go forward with the final rules or any debt relief until this case goes through its paces. So, I don't know if this one went through a more specific legal process So that could mean that it's safer than the original debt relief plan was, but the courts may still also decide that they might disagree, and that whether the secretary has the authority to do this type of debt relief or not. Now, this debt relief was pretty different from the first. It basically forgave the balance for what we call long haulers, borrowers that have been in repayment for 20 or 25 years. It also looked to bring people back to where they started. So it was going to forgive some or all of the interest for borrowers that owe more today than they did when they first entered repayment. And I'm oversimplifying this, but if you go to the Department of Ed's website, you can see what this proposal looked like. So right now that's on pause. If it does go through, if it makes it through the court, there is no application for this that we know of. But your servicer will notify you if you're eligible or if there's some way that you need to apply. But my understanding is there's no application. They have all the information they need to apply any type of debt relief to anybody who might be eligible for it. I already talked about this. Here's a link, and again, this is all on the resources page where you can find more detailed information about the proposal for debt relief. There was also something in there for borrowers that attended what they call low value schools. But that is a very detailed and intricate definition of what's considered a low value school. And then there's another proposal we're still waiting for that was purely based on economic hardship, and we don't even have the draft rules for that yet. Okay, some key takeaways. And Celina, feel free to chime in on this one if you like. First of all, PSLF is not at risk here. We get that question a lot. PSLF is written into law. Incidentally, that law was signed by a Republican president. Regardless of the outcome of the election, my personal gut feeling is that I still don't think PSLF would be at risk. Depending on the outcome of the election, they might roll back some of the newer rules for PSLF that make things a little easier for borrowers. But I personally, again, just my opinion, I don't think PSLF itself is at risk, and it's not at risk. Now, PSLF is still being processed despite the court injunctions. The one-time income-driven plan adjustments are still happening. The only thing that's paused for that is the forgiveness that as Celina so clearly pointed out. There are still accounts being transferred between different servicers. That will continue to happen. That's happened since the dawn of time. As the Department of Ed continues to try to centralize everything for borrowers, you can expect to see more servicing platform transitions. The best thing you can do is stay educated. Keep an eye on studentaid.gov. Keep an eye on Celina's organization's website, our organization's website. Read all the things. Read all your emails. Open all that snail mail. And keep an eye on your credit reports. And if you see an actual servicing error where the servicer did something that they weren't supposed to do, we do encourage you to file complaints. What I discourage you from filing a complaint about is the fact that the SAVE plan is on hold. The Department of Ed has to do what the court tells them to do. If you're fired up about that, like I am, who to write is your member of Congress. Congress can make this whole SAVE thing go away by voting for the pending legislation that would make SAVE federal law. If SAVE becomes federal law, all this nonsense goes away. So again, file complaints if the servicers make a mistake. Please don't file a complaint over what's going on with the court stuff, or because you don't like a program, because that's not, complaints are for errors, and we want that system to continue to be productive. Celina, what do you want to add to that?
I think you touched on everything. 100%. Yeah, what Betsy said, just ensure that you are on top of your communication. You can go on to the next slide. I believe this is the one. Because why is it so important? Because as all this stuff is going on and all this stuff on the news, and now we even have just a few days ago with Navient, the CFPB lawsuit, the scammers, the document preparation companies, that's what they are. They're fired up as well, and they are reaching out to borrowers and they are offering forgiveness, they're offering consolidation, they're offering to assist you. So that's why it's super important that you know who your student loan servicer is, that you know who's reaching out. It's very simple. They call me and I don't even have student loans. So if someone calls you, you can Google the 800 number, you can Google the name of the company, and you will see that there's complaints against them. It's very easy. And they sometimes I'll have websites and they say what they do, but basically, if they're charging, know that it's probably a scammer. Don't give out your login information or your FSA ID number. Do not subscribe to a monthly service or sign a contract. They'll have you sign power of attorneys, and all they're doing is they're going on to studentaid.gov, they're pulling up the information and they're filing these applications that you may not even need to help you, but they're not really helping you. In some cases, I've even seen where borrowers think they're making payments, but they're on a $0 IDR plan, and that money is not even going towards their student loan. So it's really important that you know, don't feel bad about being rude, because they will call you relentlessly. So just know that there's nothing that a company can do that you can't do on your own for free. All this information that we've provided today is on studentaid.gov. There's a lot there, so I know that it's sometimes difficult to take the time to read it, but that's why we're here today, right? No, again, your servicers, they don't even answer the phone, so they're not going to be contacting you 3, 4, 5 times a day just for anything, even not even just student loans. If someone's offering you special access or there's a sense of urgency, it may be a scam. As we've stated today, right now everything is really on hold, unless you hear something in the news with some court action, or studentaid.gov will contact you if there's a change in status where they're processing applications. Any change, they will let you know. So make sure you sign up for studentaid.gov in their newsletter as well. Just remember .org and .gov will be, if there's an email, if it's .gov, it's going to be from the state or from the federal government. File a complaint if you have been a victim of fraud. You can file a complaint with us against these scammers. We want to know, and the FTC is really also ramping up their efforts to go after these companies, because they really are defrauding victims, especially if if there's elderly borrowers and they're just super confused. They're going after them, right? Because people are really, they're desperate. So it's understandable, but just protect yourself and be aware. The next slide, please. Oh, the DFPI just started. In addition to Betsy and myself, the department has created a student loan empowerment network where you can reach out for one-on-one help. You'll be connected to one of our networks if you want additional help, somebody to actually sit down with your loans and help you. You'll get a few consultations through them. It's free and it's for California borrowers. If you have questions, though, you can send them to us. Just, simple questions. We'll be able to answer those. Next, please. And then these are some of the links we talked about today. Studentaid.gov is going to be your go-to. Information on PSLF, the link for all the save actions. They do update this sometimes overnight where I don't even find out about it. And then information on PSLF for those borrowers that had some confusion on the program. And then this will be posted on our YouTube channel. There's my email and there's Betsy's email. So if you want to get, or Tisla's email, but she's on it, so you'll you can get in touch with her through there. But that's this last slide for us.
Yeah. Thanks, Celina. I also want to thank the Rose Foundation. The Rose Foundation made a very generous grant to allow us to offer this free series of webinars. So this is going to be a series of 5 or 6 over the next 6 or 7 months or so. So keep an eye on DFPI's website as we continue to schedule these. Well, I know we'll be doing one just on PSLF. I'm sure we'll be doing one that goes into all the gory details about the different repayment plans. So keep an eye. Again, these are all free, and I do want to thank the Rose Foundation for that. This is the second year they've given us a really generous grant to allow us to be able to offer these free webinars. And we've got about a minute and a half left. Addison, what's the big question that we really need to answer for this group? I think he's busy typing or he's on mute and forgot. Addison can answer more questions in a short span of time and answer them correctly and well than anybody else I know.
Yeah, a few people have asked about the time frame, like will this be through summer when we, next summer? We don't have a we don't know. And that's what makes it difficult, right? That we don't know. These are pretty much what we discussed today is for 2024, right? We don't know what could happen within the next few months. It's all depending on the litigation. And as I said, you will receive updates, but no, we don't have a time frame for when PSLF will be, when the forgiveness will start, when PSLF will start, what months. That's why it's important to hold off on the buyback too, because you don't know really where we're at, right? So Betsy, am I missing anything? I mean, pretty much.
No, but so for PSLF folks that have been waiting for their accounts to show up at studentaid.gov, this is a gut feeling. I'd keep an eye on that website over the next couple weeks. I have a feeling we're going to see that sooner rather than later, but I'm an optimist, so we'll see. All right, Addison, anything?
No, nothing for me. We've had some great questions today, but nothing big. Just a lot of uncertainty, which we know. And thank you.
Yeah, Addison said it best. Like it's really challenging for people like us right now because people want answers. They want to be told what they should be doing, and this is uncharted territory. And it can be difficult to try to provide advice, but we do the best we can. So definitely email us with your questions, and we'll do the best we can to help you. So with that, I'm gonna call it. Thank you, everybody. Thanks for everybody that joined. Thanks for everybody that presented with me and answered questions and played the home game. You can't see her, but thanks to Alice, the student loan cat, who has kept me company during this whole thing. And have a good afternoon.
Thank you, everyone. Bye-bye.